On Monday, May 6th, the Karen Read trial continued with day 5 of testimony. And on Tuesday, May 7th, trial continued with day 6. Now, because I was out on a road trip with Mr. Bytes and our good doggo, Indy, I was unfortunately unable to stream day 5 of the trial, but I was able to watch it. So now that we got back to the office in time to stream day 6, I'm giving you a recap of day 5 and 6 together in one video. Let me just say that these 2 days together just about broke my brain. We're talking about evidence gathered in red Solo cups, lack of documentation of evidence and notes from evidence gathering. Oh, and a really big assist by the internet in sending photos that the defense say prove that a witness has in fact perjured herself. There was so much tea spilled on the Canton Police Department that I am now referring to this trial as the Boston Tea Party trial. Let's get into it. You know, now that I've covered a number of very high-profile trials, I've seen a few times where people watching the trial on the internet or wherever else realize that they have information that they can provide mid-trial to one of the parties. The best example of this was in the Johnny Depp v. Amber Heard trial. One instance was where Amber Heard claimed that she had used a particular kind of makeup palette made by a company called Milani to cover up bruising from the start of her relationship with Johnny Depp. However, when Milani got word of this allegation because of all of the coverage of the trial all over the place, they came out with a viral TikTok showing that the product didn't even exist until at least a year after Miss Heard claimed that she had started using it. And then there were surprise rebuttal witnesses who appeared in the trial, to include a former TMZ employee who Miss Heard derisively later called one of the randos. These were witnesses who watched or heard about portions of the trial and realized that they had testimony that could be of value to Mr. Depp. And so in this case, in the Karen Read trial, when paramedic Katie McLaughlin testified that she wasn't really friends with Caitlin Albert, the daughter of the homeowner in this case, the defense tried to introduce photos of the two of them from social media. They were mostly from, I suppose, 10 years ago when the two of them were in high school together. They were unable to admit those photos into evidence because Judge Canone cited Massachusetts Rule 14, which talks about discovery rules for criminal cases. Basically, she determined that the defense had sat on these photos for over 6 months or around 6 months, and that because they had them, they were required to hand them over to the prosecution back when evidence was supposed to be exchanged between the two sides. And because they didn't, the remedy that she said was appropriate was to not allow them into evidence at all. Now, that was last Friday. What we learned first thing on Monday morning was that over the weekend, the defense received what they called a deluge of photos from the public, and not from that long ago. Here's what defense attorney David Yannetti said about it.
Since Katie McLaughlin testified on Thursday and Friday, we received a deluge of photographs that put her with Caitlin Albert on many different occasions after they graduated high school. We received information from their high school yearbook that they were more than just acquaintances in high school. They were teammates on the track team. And even after I sent that email with the photographs that I attached to it, late last night, we received another photo where Katie McLaughlin and Caitlin Albert are standing next to each other in a photo at a baby shower in June of 2021, about 8 months before John O'Keefe's death. It's very clear to us that Katie McLaughlin perjured herself. And I wanted to discuss the issue of the admissibility of not only the photographs that we're now providing that we just received over the weekend, but I also want to resurrect the admissibility of H, I, J, and K for identification. And I think a discussion of this, Your Honor, needs to start with what court orders are currently in place.
Now, Judge Canone said that she would reserve some time a little bit later to review this whole issue. The defense requested that it be heard as soon as possible and certainly before Caitlin Albert takes the stand. But because the prosecution indicated that she might be called on Wednesday or sometime midweek, the judge basically said, okay, we'll talk about this further before Miss Albert gets called to the stand. So we have yet to hear the actual result of this, but there is a chance that Katie McLaughlin could at some point get recalled to the stand to testify to some more recent photos as a further impeachment of her testimony. Or at the very least, we could see these photos potentially come in through Caitlin Albert. Okay, after that, and once the jury was brought into the courtroom, we heard more testimony, and on day 5, the jury saw 2 witnesses. The first of these was Lieutenant Paul Gallagher of the Canton Police Department. Lieutenant Gallagher was one of the officers who responded to the 911 call to gather evidence after the emergency services had already been rendered. One thing that was interesting to note was that there was a bit of attention paid to the presence of ATF agent Brian Higgins. Apparently, although he's not Canton Police, he's an agent of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. He apparently had wide access to much of Canton PD's station. And this includes the Sally Port where Canton PD housed Karen Reed's SUV for a time to examine it and to remove her right taillight. From what it sounds like coming from the testimony, in the process of doing that, they actually may have shattered the taillight itself. There definitely is a question about that depending on which side you're listening to. Personally, I don't actually understand the purpose of removing it, and considering the risk of further damage to the piece of evidence, I don't understand why they thought this was a good idea, especially when the jury was actually able to view the full SUV themselves during their site visit. But back to Brian Higgins. The reason why the defense is so interested in his activities at the Canton PD station is because he allegedly was one of the partygoers inside 34 Fairview Road on the night of January 28th / morning of January 29th. But anyway, other than that, Lieutenant Gallagher's testimony was almost all about the evidence they gathered from the scene, but not in ways that you generally like to hear about police officers gathering evidence. The first thing to note about this area of testimony is that when Lieutenant Gallagher arrived on scene, John O'Keefe had already been taken to the hospital. So the only way that he actually knew where John O'Keefe was found was because other officers told him where. But the problem was he testified that he didn't actually know precisely where he was, to include whether his head or feet were closest to the street. And what's worse, Lieutenant Gallagher later directed other police officers to the place that he said he was told John O'Keefe was found. But it gets worse from there. A lot worse. When it became clear that Lieutenant Gallagher didn't know exactly how tall John O'Keefe was, defense attorney Alan Jackson asked if he'd have any problem with it if Jackson said O'Keefe was 6'1". And this was the response by Lieutenant Gallagher.
He's a 6'2" man, correct?
I don't know.
You don't even know that?
I don't know his size, no.
If I told you that he's over 6 feet tall, would you have any quarrel with that?
If Mr. Lally told me, I would take it as fact.
Fair enough.
Now, the jury is supposed to evaluate every single witness on their credibility, on their perception, their memory, their bias, etc. And so with that, this includes looking for maybe any signs that show that the witness may have some reason to get bendy with the facts in any particular direction. So this response by Lieutenant Gallagher was absolutely unwise, because it looks like he could just be fed information by prosecutor Adam Lally, and he wouldn't blink an eye and just adopt it regardless of any truth behind it. That's a huge problem for his credibility, and I was astounded because I thought that was an absolutely ridiculous response. And the thing is, he also said it with such confidence that it seemed like he actually thought that he was doing the prosecution a favor with that response. And it makes me wonder how well the prosecution actually prepared this witness to testify at trial. But it went on, and it got worse. Defense attorney Alan Jackson also asked if anyone drew up a report detailing exactly where John O'Keefe was found. Lieutenant Gallagher said that there was no such report detailing this kind of information. And then the witness also said that in his 30 years of policing in the Boston area, he had never processed a crime scene in the snow somehow. Now, I can understand that coming from a police officer in Southern California, where I'm from. But Massachusetts? Really? In 30 years? That was a weird response to me. But not as weird as this comment.
You indicated that you had never preserved a crime scene in the snow before.
That's correct.
30 years plus, and your policing experience is here in the Boston area?
Correct.
Snow's a lot.
Sure.
In 30 plus years, you've never processed a crime scene in the snow?
No, I have not.
Lucky you.
Well, we don't typically process our own crime scenes. Sometimes we use the state police, sometimes we use Plymouth County detectives.
Now, the thing is, the defense has every interest in highlighting for the jury anything that can point to anomalous activity in this case. In other words, things happening in this case that aren't the usual, the norm. And that's because there's this big allegation of police corruption in this case, that they made an exception to their usual standard procedure to sort of massage some things to make things look a certain way. So pointing out that they really usually don't even process their own crime scenes, but that they decided to, for one reason or another, after a police officer was found dead on the ground of another police officer's lawn, things start to look a little bit weird. I'm not going to lie. And this is where things actually get really wild. Because at this point, Lieutenant Gallagher starts going over how the Canton Police Department decided to actually process the scene. First, he described using a leaf blower on a low setting to push off the snow that had fallen over the evidence over the hours because it had been actively snowing all throughout the morning and day. And as had been reported many times in this trial, it was snowing pretty heavily in the Boston area on January 29th, 2022. So they used the leaf blower to combat that in a way. Now, I admit I was skeptical of the ability to use a leaf blower to carefully dig up the evidence like some kind of an archaeology site. But seeing the video of it, I'm not completely bothered by it because it does appear to be on a very low setting and not moving things in a way that I typically see leaf blowers sending things flying absolutely everywhere. That said, I'm sure that there are plenty of people who still have a huge problem with the use of a leaf blower in a crime scene like this. But I don't know if it's just my California upbringing, but to me, it seemed like they were using a bit of control there and was able to actually move the snow in a way that seemed like it was okay. However, the rest of Lieutenant Gallagher's testimony about evidence gathering had me absolutely spinning. This was most of all because of the way in which they went about gathering the blood samples that were found in the snow at the crime scene.
And you indicated your testimony was temporary evidence containers to collect that blood, correct?
Yep, we utilized cups, plastic cups.
Those were red Solo cups, right?
That's correct.
The same kind of red Solo cup you drink beer out of at a barbecue?
Yeah, sure, you could.
Objection, Your Honor. Strike.
I'll allow it.
There's nothing special about the red Solo cup?
Other than their plastic, nothing special.
And where did you get those red Solo cups?
We got them from Lieutenant Gallagher.
So in other words, you got the, to use your words, the evidence containers from a neighbor.
Correct.
He had some Solo cups in his house.
Now, we asked him if he had any plastic containers, any type of plastic container that we could utilize.
I'm sorry, what?
How far were you from Canton PD? From 34 Fairview to Canton PD? Give me an idea.
Mile and a half.
So even in really bad weather, 4 minutes, 5 minutes, is that right, to drive?
Sure.
You didn't go back to Canton PD to get actual evidence containers, correct?
We wouldn't have temporary plastic containers that what we were looking for. We're looking to take samples of snow. We wouldn't have had, I know for a fact we did not have those. If we needed bags, needle containers, things of that nature, we're all set. But as far as plastic containers that we wanted to utilize, we didn't have them.
Do you have any glass containers?
No.
So Canton PD does not have or utilize evidence collection containers that are plastic?
We have needle containers that are plastic. We have blood swabs that are in plastic containers. But for what we wanted to take a sample, we did not have. So we improvised.
My next question is, certainly Canton PD employs and owns sterile swabs.
Correct.
Sterile swab is in a container that's long, and usually the swab is connected to the lid, pop
Correct.
it out, and then it's sealed
That's correct.
and forensically stable, correct?
Yes.
And the reason that it's sealed and forensically stable is so nothing can contaminate the sample, correct?
Sure.
But
Yes.
just as importantly, the blood sample can't contaminate anything else.
Correct.
Did you go to Canton PD a mile away and get sterile swabs for the blood collection?
Blood was frozen. We didn't think it would be viable.
You didn't think it would be viable?
Correct.
If you touched the swab to cold blood, you think you might get some blood on that swab?
I wasn't sure it would be efficient for testing.
So what you did instead was you gathered red Solo cups from a neighbor, unsterilized, and scooped up the snow with what you thought the blood was and just carried them back to the truck?
Nope, we took 6 samples, individual samples. Our philosophy was we'll let the crime lab extract it the way they best see fit. Those 6 samples were bagged and then transported back to Canton Police Headquarters and placed into evidence.
Were they covered?
No, not that I recall.
They weren't sealed in any way?
No.
So if somebody sneezed over the top of one of those cups,
They were sealed in a bag, brown evidence bag. At that time, nobody was going to sneeze over the cup.
do you have any idea how many people before you had handled those solo cups?
I took them out of a package, so probably none.
How about before they were packaged?
I assume Solo doesn't sell contaminated cups. I would say none.
So they're certainly not forensically stable. They're not sterile.
By your, I don't know what definition you're looking for, but I would agree.
So, in other words, they didn't use normal evidence containers to gather this blood. They were a mere 5-minute drive, even in the worst snowstorm, from the Canton PD station. And they didn't even make sure that the non-closable red Solo cups that they were using were sterile when using them to gather blood evidence.
Red Solo cup, I fill you up. Let's have a party. Let's have a party.
But at least they were placed in a sealed brown evidence bag to make sure nothing else got in there, like someone sneezed some DNA, for example, right? Defense attorney Alan Jackson then asked about what actually happened to the blood samples when they ultimately got to Canton PD station.
I'd like to ask you if you recognize what's depicted in this photograph, especially the area right down here on the right, bottom right. You see that white rag?
I do.
Lieutenant, if you take a close look at that rag, I'm going to ask you to identify it on the photograph. Do you see a couple of little dark marks on what appear to be that?
I see it on that screen.
Better visual up there. Okay, fair enough. What's the position of that rag as it relates to the vehicle in the photograph?
It's the rear passenger side.
Right rear quarter panel, correct?
Yes,
Okay. And is that, in fact, the SUV in question?
I believe it is.
Okay. The SUV that belonged to Miss Reed.
I believe it is.
Looking at 38, does that appear to be the same rag in the photograph?
It does, yes.
Okay. You see a shadow sort of looming over the top of the photograph?
I do.
Given what you just said about evidence item 37, does that appear to be the shadow of the right rear quarter panel of the truck?
I would guess it's the tailgate.
So you can't guess.
I would say it was the tailgate. The tailgate's up, maybe the tailgate's up at this point.
You see a bag in the middle of the photograph.
Yes,
Can you read what's on that bag?
Stop and Shop.
Okay, that does not look like an evidence bag, does it, sir?
No,
Matter of fact, it looks like a grocery bag.
correct.
Is that right?
Yes,
So, not a forensically stable item, correct?
correct.
Certainly not sterile.
Correct,
Right.
correct.
You know where that bag came from?
I do not.
Was that a bag that you supplied to Sergeant Lank?
I do not know. Do not recall.
Lank got the Stop and Shop bag.
I do not know.
Next photograph, please.
39?
Taking a look at what's been marked as evidence item 39, you recognize what's in the middle of the photograph.
Yes,
What is that?
those are the plastic cups with the coagulated blood.
Do you see on the top of the photograph the same rag
I do.
with the same markings?
Yes,
That appear that those unsealed cups with liquid blood in them are situated right near the right rear quarter panel of the SUV in this photograph.
they are to the rear of the vehicle. Yes.
And next item, please. And this appears to be evidence item 40. You see the same white rag,
Yes,
and you see the same evidence bag, Stop and Shop bag, correct?
correct,
And it's filled with 6 solo cups
correct,
with what appears to be liquid blood.
correct.
So again, this blood is not in sterilized packaging, it's not sealed in any way, and it's not even in a proper evidence bag, it's in a grocery bag. The defense at this point has done an amazing job highlighting the terrible job that the police have done investigating this case. At this point, it doesn't matter if the blood evidence was even crucial to the case or not. You don't even have to be a lawyer or a member of law enforcement to know this. Everyone who has even gotten their information about police investigations from pop culture knows how you treat blood evidence, and this is just not it. Now, I can't speak to what's going on inside the minds of the jurors, of course, but if I'm on the jury, there's absolutely no way I'm trusting Canton PD to do anything right in this investigation from this point forward. At this point, there's reasonable doubt everywhere, in my opinion. But now, Lieutenant Gallagher was also questioned about other evidence at the scene. He said that with the leaf blower, he was able to get basically to the ground after uncovering the snow. But despite that, he said that he never found John O'Keefe's missing shoe, missing hat, or any bright red, black, or clear tail light material. And the defense highlighted that even though Lieutenant Gallagher at some point went inside 34 Fairview Road as far as the front room to interview the homeowners, he didn't go to search the home. He didn't take any notes from any of this, the interviews or the evidence gathering, nor did he write up any kind of a report. But the reason he gave for not searching the home was that there was no probable cause for a search warrant. And I will say this actually might be true. Although there was a dead body found on the front lawn of a homeowner, keep in mind that the front lawn is accessible to the public essentially. Anything can happen on anyone's front lawn in the middle of the night, and the homeowner might be completely unaware of it until first responders actually wake them up to inform them about it. So that on its own is probably not enough for probable cause. And keep in mind that probable cause is actually a higher standard than, say, reasonable suspicion. Reasonable suspicion is where a police officer might be observing the public and there's just something weird that they're seeing that would give a reasonable officer suspicion that a crime may have happened or may be happening. As an example, let's say that it's the middle of July in Southern California, like I said, where I'm from, and you can see that someone walking down the street is wearing a very heavy overcoat that appears to be somehow bloated underneath. A police officer might have a reasonable suspicion that they're hiding some kind of stolen goods under there. So that might give them the ability to stop the person to do a reasonable search of that person. But probable cause requires something a little bit more than reasonable suspicion. The officer needs to have facts and circumstances that are sufficient for a reasonably cautious person to believe that a crime has been committed. And this has to be based on reasonably trustworthy information. And so here, Lieutenant Gallagher said that there wasn't any probable cause to support a search warrant of the house. Now, I would agree that the fact pattern of a body showing up on a front lawn probably isn't enough to meet that standard. If it was found inside the home, that's a different story. If it was found in the backyard, also a different story. But anyone can really wander onto someone's front lawn and collapse, and it could be complete serendipity. But the thing is, that probable cause analysis can change as more facts come in. And when you realize that both parties were local cops, that there was a social connection between them, and that they in fact had been drinking together in a bar the night before, things start to look a little bit different. But regardless of the probable cause question and analysis, there's a way that officers could have actually gotten access to the house legally without a warrant, and therefore without probable cause. And that's by getting permission of literally anyone who lives in the house. If the police can get consent to enter and search, they don't actually even need a warrant to begin with. And Lieutenant Gallagher admitted that he never even asked for permission to enter the house to search it. And by all appearances, no one else did either. They basically said, well, there's no probable cause, most likely, so dead end, guess we won't go inside and investigate. Which, to me anyway, looks at the least like lazy police work, and like the worst, it could be a police cover-up. Where it falls along that spectrum probably depends on the individual. Okay, so that was Lieutenant Gallagher. Next, we heard from Sergeant Sean Goode, also from the Canton Police Department. He was working police dispatch at Canton PD station at the time that the 911 call came in, so the jury got to hear the 911 call from Carrie Roberts as well as one from Jennifer McCabe. It was kind of hard to hear the substance of the calls due to the quality of the recording, the acoustics in the room, and the fact that it was all coming in through a second recording through the media pool. But anyway, Sergeant Goode also testified that when he arrived on scene, he spoke with all three of the women. He said that Karen Reed was hysterical and couldn't keep her train of thought. He said that she kept repeating, yelling, "Is he dead? Is he dead?" And later on cross-examination, he also would confirm that he never in fact heard Karen Reed say, "I hit him," and that the statement doesn't actually show up anywhere in Sergeant Goode's report that he ultimately wrote on the incident. He also testified that Karen Reed told him that she didn't know how John O'Keefe had gotten there. Then a bit later, Sergeant Goode said that he heard that she was making statements over the phone to her dad that indicated that she wanted to harm herself. Her dad apparently was so concerned that he called in about it. And so Sergeant Goode is the one who actually ordered that Karen Reed be Section 12. So that's why she was taken to the hospital for a psychological evaluation. Now, Sergeant Goode also testified to knowing who Brian Albert was at the time that he was there investigating the scene, since Sergeant Goode worked with Brian's brother, Detective Kevin Albert, for years. It also came out later on cross-examination that Sergeant Goode had graduated high school with Trooper Michael Proctor's sister and with Christopher Albert's sister-in-law. To me, that's not really enough to really prove a social connection between Sergeant Goode and these others, especially depending on the graduating class size. However, him having a professional working relationship with Detective Kevin Albert does seem to be material. And the defense really does want to put every opportunity out there to show all of the ways that these people are interconnected. Anyway, Sergeant Goode said that he and Sergeant Michael Lank conducted interviews of Brian Albert, Nicole Albert, and Jennifer McCabe just inside the house. But apparently, they interviewed them all together in one room. That means that the individuals could all hear what the others said during their interview, which means that there is a possibility of them lining up narratives in these various interviews. Now, keep in mind that that on its own doesn't necessarily mean that it actually happened, that they did in fact line up narratives for the interviews. But the whole point of doing these interviews separately and out of earshot, as is generally standard procedure for these kinds of things, is to prevent the possibility of that happening. So now the door is opened as to whether or not they actually intentionally lined things up. Anyway, Sergeant Goode also testified about the evidence that was gathered using the leaf blower to uncover anything under the snow. He also agreed that they got basically down to the bare ground and yet found no taillight pieces, no shoe, and no hat. At 8 a.m., they decided not to bother with caution tape anymore because of the wind and the other elements, and they reopened the crime scene. This means that as of this point in time, 8 a.m. on January 29th, 2022, there was no one standing guard to make sure people didn't walk through and mess with the crime scene. There also was no crime scene tape. There was nothing indicating that this even was a crime scene to begin with. Essentially, they were done picking up evidence, and that was it. Now, at the end of his testimony on day 5, in cross-examination, an issue in Sergeant Goode's incident report came up. On the incident report face sheet, the front page of the report, it says 32 Fairview Road. Then in the narrative of the report, it says 34 Fairview Road, the actual address of the place where all this happened. So we have another discrepancy in the details of the reporting. Now, when things picked up again on day 6, Sergeant Goode's testimony on cross-examination continued, and we learned about more discrepancies in the incident report, and this seems to be even worse. Defense attorney David Yannetti introduced 2 different versions of the same report's face sheet, one marked as Exhibit P and one marked as Exhibit Q. And both of these were supposed to be essentially the same report written by Sergeant Goode, just printed on 2 different days. Exhibit P shows a photo of a berm appearing in the snow, and it was printed on January 30th, 2022. Exhibit Q, however, shows a photo of a red piece of plastic taillight in the snow. It was printed on October 25th, 2022.
Sergeant Goode, you have previously testified about the details in these reports. You would agree that each of these reflects your report. It says Reporting Officer Sergeant Sean Goode, correct?
Yes.
Each of these is page 1 of your report, correct?
Yes.
You've previously testified that you call that the face sheet of the report, correct?
Yes.
Each of these has the identical incident number and call number, correct?
Yes.
The identical details in these reports. You have... Okay. Sergeant Goode, you have previously testified about the details in these reports. You would agree that each of these reflects your report. It says reporting officer Sergeant Sean Goode, correct?
Yes.
Each of these is page 1 of your report, correct?
Yes.
You've previously testified that you call that the face sheet of the report, correct?
Yes.
Each of these has the identical incident number and call number, correct?
Yes.
The identical date and time reported, correct?
Yes.
The identical report date and time, correct?
Yes.
And of course, the identical officer.
Yes.
Other than the print date of the face sheet of your report, one appears to be in January, one appears to be in October, the major change is the photo that's included on the face sheet, correct?
Yes. Can I explain why?
So that second photo with the piece of tail light that is included on the first page of your report, that photo is not from January 29th of 2022, correct?
Correct.
You never took a photo of a piece of taillight on January 29th of 2022, correct?
Correct.
You never saw a piece of taillight at 34 Fairview on January 29th of 2022, correct?
Correct.
Did you personally switch the photo on the face sheet of your police report?
No.
Do you know who did?
So whoever updated the report, their supplemental, you add photos.
But in answer to my question, do you know the specific person from your department who altered the photo on the face sheet of your report?
I didn't take the supplemental report, so I don't know.
Okay.
I don't know who took the photo.
But given that this is your report, you're the reporting officer, you are responsible for the content of that report, are you not?
For my report, yes, not other officers' supplementals to an investigation.
All right, but this is your report. This is the face sheet for the reporting officer, Sergeant Sean Goode, is it not?
Yes, on the face sheet.
All right.
If you look at these two documents, there's absolutely nothing on either page to indicate that one of these is an original and the other is in any way supplemental or updated. And this, in my opinion, is a huge problem for the integrity of Canton PD's record keeping. And as I already said, Sergeant Goode never even saw taillight pieces on the ground, nor did anyone else on January 29th, 2022. So the whole purpose in creating these reports is to document what the police knew and when. So this photo swapping on the face sheet of the incident report is absolutely wild because it means we can't have any confidence in the fact that the police are actually keeping accurate records of what was known and when. And I will say, I know that a lot of people have been banging the drum for a long time that Karen Reed was framed by the local police. Up until day 6, I saw a lot of really incompetent investigative work. And that has continued through day 6, to be honest. And at various points in time, I've noted that it is possible that these various pieces of shoddy police work could be evidence of a police cover-up. But there's nothing that so far has really jumped out at me to say, this on its own looks like more than police incompetence. This looks like a police cover-up. That is, until this whole supplemental, non-supplemental, maybe supplemental incident report came to light. I'm not gonna lie, this is where things start to look like there is in fact a conspiracy to frame someone. Now, I'm still not ready to conclude that there in fact was a conspiracy to frame Karen Reed. However, I'm just calling it like it is. This is what I see. That's how this looks like. This is starting to lean in that direction. Anyway, that was Sergeant Goode. Next up was Sergeant Michael Lank, also with the Canton Police Department. Now, at the end of day 5, the attorneys on both sides conducted a voir dire of Sergeant Lank outside the presence of the jury. The purpose of the voir dire was to go down a line of questioning to see whether it was permissible to ask certain questions about Sergeant Lank's history with the Albert family. And essentially, Judge Canone did allow the defense and the prosecution to pretty much ask all of the questions that they wanted to, just about. The defense wanted to get in an incident from 2002 where Sergeant Lank got into a fight fight with members of the public, basically on behalf of his friend Christopher Albert. This was when Sergeant Lank was off duty and had been drinking at a bar, and he was sitting in his car in the parking lot when Christopher had come up to him in the parking lot to tell him about a fight that he had just gotten into with a group of people. Christopher also said that these guys, who apparently were brothers, had made threats against Christopher's family. Then, as they were continuing to talk in the parking lot, apparently these other guys came back for a second fight. Sergeant Lank said that he tried to verbally ward these guys off. Then when things escalated, he called for Canton PD backup and activated himself from off duty to on duty. Then a fight ensued, and Sergeant Lank said that he punched one of the guys after one of the other guys had already hit him. Eventually, Canton PD showed up and broke everything up. One of the other guys had run away, another got handcuffed, but he was ultimately released and no arrests were made. The next day, or sometime very soon after, the other guys showed up apparently at the Canton PD station to file a police report against Sergeant Lank over the whole thing. And then the rest of the police officers who were there, to include Sergeant Lank, wrote up their own police incident reports about the incident. Now, it sounds like nothing really came of this, but the defense wanted to talk about it because it can create the appearance that the Canton Police Department is essentially made up of a bunch of so-called good old boys who take care of their own, whether above board or not. And I can see this playing out for some people. To me, it's not the most convincing story towards that end, but it does show Sergeant Lank going way back with Christopher Albert. And that's another thing that came out in Sergeant Lank's testimony, is the fact that he's been friends with the members of the Albert family since he was around 12, 13, or 14 years old. He's apparently closest with Christopher Albert, who seems to actually have been a very close friend of his. He said that he also knew Tim Albert, the younger brother, and says that he had met Brian Albert, but basically only knew him as the older brother of Chris. Still, this is an overall friendship with a family that goes back decades. So the fact that Sergeant Lank had such an intimate role in conducting interviews of Brian Albert, Nicole Albert, and Jennifer McCabe does feel uncomfortably close for a proper arm's length investigation. But then, on cross-examination, they turned to Sergeant Lank's involvement in the evidence gathering. Sergeant Lank also said that on January 29th, 2022, he searched for evidence and didn't find any taillight pieces, a shoe, or a hat. He did, however, find the blood that we already know about. And as it turns out, Sergeant Lank is the one who actually scooped them up into red Solo cups.
Red Solo cup, I fill you up.
So the jury got to hear this whole procedure hammered in all over again, and somehow this time it seemed worse because he tried to explain away the fact that the Stop and Shop bag wouldn't have any evidence label or evidence tape that we typically see on a brown paper evidence bag.
That appear to be the same 6 Solo cups?
That you just showed me in the previous slide?
Yes.
Yes.
Are those the same 6 Solo cups that you gathered at the scene at 34 Fairview and ultimately brought back to Canton PD?
They certainly appear like they are, but I can't say definitively, but they appear to be.
I'm sorry, I didn't mean to step on your words. Go ahead. Pretty sure.
They appear to be the same Solo cups, but I couldn't say definitively.
Let's go back to tab 24. And the reason you can't say definitively, Lieutenant, is because there is no label on this bag, is there?
Not on that side of it, no.
There is no property number on this bag, is there?
Not on the side that's visible to me, no.
There's no evidence tape on this bag, is there?
Not on the side that's visible to me, no.
Well, let's look at the other photographs. Are you well, before we do that, are you suggesting that all of that material is on the other side of this bag?
I don't know. I'm not suggesting anything. I'm telling you I don't know.
Okay, let's look at the next tab. Looking at it from the top, does it appear anywhere from that vantage point that there's evidence tape that's ever been put on that bag, that has ever been secured?
I wouldn't be able to tell you that.
Well, one of the ways that you can tell that evidence tape has been put on an item is because when the evidence tape is placed on it, it's completely sealed. And if, in fact, that seal is ever broken, it's not torn off, it's cut, and there's initials put on, correct?
Objection.
Sustained.
Have you ever used evidence tape before? To seal anything?
I'm sure I have. I don't recall off the top of my head.
How long have you been a detective? I'm sorry, how long were you a detective when you were a detective?
I was a detective for 11 months as a sergeant, and then I was a detective for 15 months back in 2011-12.
And in your experience, and how long have you been a police officer?
Over 24 years.
So in your 24 years of experience and over a year as a detective, you can't remember if you've ever used evidence sealing tape?
As I said, I'm sure I have. I just can't recall one off the top of my head.
If you can recall using it at all, isn't the protocol that when evidence sealing tape is used to seal an item of evidence, when it's removed, it's not torn off, it's cut, and then new sealing tape is put over it with an initial and a date, correct?
Objection.
Do you know the answer to that?
I don't.
And the thing is, this actually looks way worse because shortly before this, the jury actually saw exactly what a proper evidence bag is supposed to look like, because on direct examination, prosecutor Adam Lally had Sergeant Lank present a broken cocktail glass that he says was found next to John O'Keefe's body. And when he did, he pulled it out of a properly sealed evidence bag. So again, the jury has seen exactly what an evidence bag is supposed to look like, and now they've seen the actual conditions of the storage of the blood in a non-evidence bag, not labeled, not sealed with any evidence tape. What an absolute nightmare. Anyway, the last witness of the day was Lieutenant Charles Ray. He is also from the Canton Police Department, and he testified that on January 29th, 2022, he went to do a wellness check on John O'Keefe's niece and nephew since they were under John's care and under his guardianship. Initially, it seemed like there was really nothing interesting coming out of Lieutenant Ray's testimony at this point in time. But then the prosecution showed dashcam footage, which ended up with a view of the back of Karen Reed's SUV. And I will say that for once, this was the prosecution seeming to make a good move in this trial, ending the day with the jury looking at the SUV's taillight before the SUV was towed. And when you look at it, it does look like it's already missing basically a huge chunk of red pieces on the right rear side. However, at this point in time, the jury has seen so many dash cam videos of officers driving, and finally arriving on scene. And none of those has ended up being important until they're actually at the scene and there's things happening on the dash cam in front of them with the paramedics and with other people walking around. But the actual driving portion of these dash cam videos has never been important up to now. So when I said in an earlier recap that the training that these attorneys do for the jury's attention in the beginning can either help or hurt their case, this is exactly what I'm talking about. Personally, I myself saw that we had yet another dash cam driving video and thought, okay, this isn't going to be important, and I relaxed my attention. And I actually initially missed the fact that they ended with this visual. It wasn't until I went back that I noticed, hey, that's really not a bad move by the prosecution. But if I didn't notice it, there is a chance that the jury also didn't. And especially at the end of a day when their attention has already been pretty taxed with testimony. So we'll see what happens on day 7 when the prosecution once again picks up direct examination of Lieutenant Ray. If they start with this image again, the attentional issue is a bit less of a concern for the prosecution, I suppose. Especially if the prosecution actually flags it verbally for the jury. But we'll see. At this point, I see so much reasonable doubt in this case. It is absolutely astounding the way in which the police department has gone about gathering the evidence in this case for this trial. But those are my thoughts. What do you think? Do you see reasonable doubt, or do you think that I am going off the edge in favor of the defense here? Do you think she's guilty, not guilty, or unsure yet and waiting for more facts as they unfold at trial? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of the Karen Reed trial, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded, because we are doing daily recaps and daily live streams gavel to gavel of this case from beginning to end, minus day 5, of course. But other than that, we should be good to go on every day of this trial. All right, see you in the next one.